Today, in his most recent public appearance, the president demonstrated a clear absence of the steady judgment and composure required to fulfill the responsibilities outlined in our founding document. The individual currently in the Oval Office appears to lack basic rational thinking and measured choices. Keep in mind that this is the same person who holds the authority over nuclear launch codes that could bring catastrophic harm to the planet. Donald Trump is showing intense frustration right now following a ruling from federal judge Marianne Keller. She has required the immediate disclosure of a large volume of materials that his legal team worked tirelessly to protect from public view over an extended period. This isn't an ordinary batch of paperwork. It involves transcripts of private conversations capturing his exact statements, financial records detailing the flow of money, and internal communications that appear to suggest improper directions given to subordinates. These items are becoming accessible as we speak. What makes this particularly sharp is the manner in which the ruling came down. The judge chose not to issue a routine written order that could be quietly contested on appeal. She instead stated her complete findings aloud during an open court session with cameras present to record every word. She carefully explained the shortcomings in each argument that Trump's side raised for keeping things sealed. She emphasized that the American people have a legitimate interest in seeing this information. She rejected concerns that disclosure would interfere with ongoing investigations. She set aside claims of potential unfair prejudice, and she insisted on full and prompt release with no opportunity for further delays. Trump's lawyers sat through this in the courtroom itself. They listened as the judge systematically addressed and rejected every one of their positions in front of the public. This represents a severe defeat that exposes the complete failure of the strategy to shield these records indefinitely. The evidence he sought to keep buried is now available for examination by investigators and prosecutors looking into potential misconduct. Trump understands the serious danger this poses to his legal standing. People in Washington recognize it as well. If you're following these major developments closely, consider subscribing. It supports the work we do here on The John Brown Show. Our goal has always been to provide straightforward reporting grounded in the full context. Let's move into the specifics of what happened. The order to unseal covers a broad array of records that Trump had long attempted to protect. These include notes from private meetings between him and his inner circle, financial trails that reveal transactions he wanted kept out of sight, and various electronic communications such as emails, texts, and memos. All is now entering the public domain at this moment. Judge Keller concluded that the value to the public in having this transparency far outweighed any personal interest Trump had in maintaining privacy. In response, he has erupted on his social media platform, posting sharp criticisms and describing the process as a form of judicial harassment while directly targeting the judge. But this is not an instance of selective targeting. It is a federal judge applying established principles of openness in the justice system. She carefully weighed his arguments for secrecy, found them unpersuasive, and required disclosure because citizens deserve insight into the conduct of their leaders. She reviewed the contents Trump wanted withheld and affirmed that ordinary Americans should have the chance to examine them. Share this with others, because every time Trump attacks Judge Keller for promoting transparency, it only reinforces the impression that he is trying to hide something damaging. It creates a self-reinforcing pattern that makes him look more evasive and accelerates the legal pressures he faces. Now let me highlight the main reasons this ruling landed with such force and left Trump with limited options. By delivering the decision verbally in the courtroom, Judge Keller created a deliberate choice. She could have written it out, allowing his team to study it privately and prepare objections. Instead, she spoke it directly, turning the moment into a recorded public event that reached a wide audience and made clear exactly why his secrecy request did not succeed. Think about the effect of that approach. When arguments collapse so completely that a judge announces the rejection out loud in session for maximum visibility, it signals an unambiguous defeat. The judge transformed the loss into something undeniable and visible to all. It sent a clear message across the legal community. Efforts to conceal evidence like this are no longer viable. Courts are increasingly prioritizing openness. The broader interest in public accountability takes precedence over individual desires to suppress material. When a judge at this level publicly rejects Trump's confidentiality claims, it encourages similar decisions in other cases. We are already seeing that pattern emerge across multiple legal matters. Judges are denying attempts to seal records and ordering releases, recognizing the same flaws Judge Keller identified. The arguments presented are often designed more for personal protection and avoiding accountability than for legitimate purposes. Consider the serious matters these newly available files reportedly connect to. They involve multiple grave issues that together create a troubling picture for Trump, starting with alleged improper directives, communications that seem to show instructions to staff members to take actions outside legal bounds. This goes beyond policy disagreements. If verified, it points to deliberate efforts to violate statutes. There are also connections to the January 6th events with materials that reportedly address efforts to manage the fallout from the Capitol attack, what he knew at the time, his reactions, and steps taken by his team to downplay his role. Then come financial irregularities, records that appear to track transfers and arrangements crossing legal lines, money moving to improper places, indications of corruption or personal benefit, and possible obstruction of justice, discussions that allegedly involve plans to hide evidence, coordinate stories, and mislead investigators. Taken as a whole, these paint a portrait of a leader who repeatedly disregarded legal boundaries, used power for self-interest, and then tried to cover the evidence. Make sure you're subscribed because the accelerated schedule for full disclosure gives Trump almost no time to control the consequences. In many cases, judges phase out releases gradually, allowing periods for challenges over weeks or longer. Judge Keller required everything to become available without delay. No final attempts at blocks, no appeals to favorable venues, no window to shape the narrative. The entire collection arrives in the open simultaneously. This is a sitting president watching long-guarded materials surface all at once, something without a clear precedent in American history. The verbal delivery also leaves a permanent record. The courtroom proceeding was captured on video. The judge's step-by-step breakdown of why the claims failed becomes part of the historical record, influencing how this presidency is remembered. It also establishes guidance for future proceedings. Other judges can cite this ruling when similar secrecy requests arise elsewhere. A clear standard is solidifying. He can no longer successfully shield this kind of evidence. Let's examine more closely what was released, what it is said to show, and why it carries such significant legal and political risk for him. The transcripts from those closed-door sessions capture his unguarded remarks when he thought they would stay private. In those settings, people tend to speak freely, reveal genuine intentions, and discuss strategies. These reportedly contradict his public positions. They suggest he understood certain actions crossed lines. They indicate recognition of potential wrongdoing. Recorded words are hard to dispute or rewrite. Financial records offer concrete evidence of money movements, not opinions or legal spin, but actual transaction paths. They reportedly reveal improper payments, efforts to obscure funds, settlements, and personal gains. Arguments can be reframed, but ledgers showing money to restricted areas stand as fact. The internal messages document decisions in real time. Who knew what when, who gave orders, who raised legal red flags. They reportedly confirm directions toward unlawful conduct and awareness that it was problematic. That captures intent in writing. If the alleged improper directives hold up, they show him instructing others to break laws. That amounts to coordinated wrongdoing. Each such instruction could support separate charges. Those who carried them out might become witnesses. The potential violations multiply with each document, revealing misguided guidance. This is direct evidence of misconduct, not speculation. His own reported words directed it. The January 6th related items stand out as especially damaging. Materials reportedly indicate he knew the violence was happening, understood security failures, did not intervene to stop it, and later worked to minimize his involvement. That combines failure to act with interference. Multiple serious issues from a single day. Post-event discussions allegedly show coordination on how to present the narrative, whether to destroy records, what to tell investigators, which suggests consciousness of guilt and obstruction captured as it occurred. This disclosure has broad implications for his other ongoing legal battles. The released material can feed into criminal prosecutions, civil litigation, and congressional inquiries. Everything interconnects. One unsealing creates ripple effects across his cases. Prosecutors in different jurisdictions now have access to evidence they didn't before. Financial irregularities tie into state-level matters. Messages relate to federal obstruction. January 6th details support Capitol investigations. The session records lock him into positions hard to escape. If he testifies under oath anywhere, inconsistencies with these private statements could lead to perjury risks. The documents set unavoidable traps. The financial trails will likely prompt extended investigations. Start with one unusual transaction, follow it, uncover others, and build a pattern of corruption. One leads to many. The communications establish knowledge and intent. He reportedly recognized risks, discussed them, and proceeded anyway. That's the key element prosecutors need for charges. Reports suggest members of his inner team are reviewing the materials, with some expressing private concerns about what they reveal regarding his conduct and fitness to continue in office. Such internal doubts from close associates highlight the damage. The logic behind his strong reaction is direct and severe. These files undermine his defenses, contradict his public accounts, and provide grounds for numerous potential violations. He knows full scrutiny could lead to profound legal jeopardy. Authorities will use it. Congress will probe deeper. Opponents will leverage it. So he is pursuing a calculated strategy. Attack the judge, attack the process, frame the release as a biased pursuit. Then he can tell supporters the evidence lacks validity because it emerged improperly. That approach has limits. The materials are public regardless. But he continues, and when he publicly criticizes judges this way, it often escalates matters, inviting more scrutiny, additional signs of interference, and pressure on the system. That's the cycle we see unfolding. Frustration building, broad attacks, self-inflicted complications. Subscribe if you want to stay informed, because this mandated release represents one of the most significant exposures of evidence since these inquiries began. Materials he resisted revealing for years are now out, not in fragments but as a comprehensive set. Meeting records, financial details, communications, and the full scope. Such volume creates immense pressure affecting every dimension. How charges are evaluated, how defenses are judged, how public perception forms, how allies respond. He can call it a witch hunt repeatedly, but it doesn't change the core fact. A federal judge ordered this transparency after finding his secrecy arguments insufficient and determining that openness serves the greater good. In closing, Trump is deeply upset. Judge Keller has required the immediate public release of extensive evidence, including private meeting transcripts, banking records, and messages that reportedly show improper instructions to staff. He thought these would remain hidden indefinitely. The judge delivered her full reasoning verbally in open court on record, explaining point by point why each secrecy claim failed, affirming the public's right to know, dismissing interference worries, rejecting bias arguments, and demanding no delay disclosure. His legal team witnessed the dismantling of their case in real time, a major setback that reveals his concealment efforts as unsuccessful. The evidence is now open for investigators and authorities pursuing violations. He is lashing out online, calling it persecution and targeting the judge personally. But this is simply a judge upholding transparency rules, weighing claims, finding them weak, and prioritizing public knowledge after reviewing the contents. Each criticism only strengthens the perception of hiding wrongdoing, feeding a loop that increases suspicion and hastens his legal challenges. The public delivery made the defeat stark and inescapable. She could have written it privately for appeal preparation, but chose an open statement, a recorded event that clarified the failures for all. It signaled to the legal world that concealment tactics are failing. Courts favor accountability, and public interest prevails over personal secrecy. A judge of her standing rejecting these claims empowers others to do the same. We're seeing that shift in cases denying seals and requiring releases for the reasons she outlined. The unsealed items connect to severe allegations, improper directives reportedly showing illegal instructions to staff, and potential conspiracy. January 6th materials reportedly cover awareness of the attack, inaction, cover efforts, financial records of questionable deals, misplaced funds, corruption signs, obstruction of discussions on hiding evidence, and misleading probes. Together, they suggest a pattern of rule-breaking, self-serving power use, and cover-up attempts. The immediate release left no buffer for response management. Unlike phased disclosures in other cases, everything surfaced at once for the current president. Unprecedented, the verbal ruling creates a lasting historical impact, with explanations preserved on video and available as precedent for similar future claims. He faces tighter constraints on secrecy going forward. Meeting transcripts capture unguarded truths, reportedly clashing with public statements and showing awareness of issues. Financial logs provide undeniable transaction evidence of irregularities. Messages document real-time decisions and intent toward wrongdoing. Alleged directives, if confirmed, indicate law-breaking coordination. January 6th files reportedly show duty lapses and interference. These materials feed widely into other cases, prosecutions, suits, and probes, linking issues across jurisdictions. Financial trails spark long investigations. Communications prove knowledge and purpose. Inner Circle is reportedly reviewing with concerns about implications. Backlash strategy targets the judge and system to discredit, but materials remain public, and attacks risk further complications. This marks the most extensive evidence release yet. Full trove, hitting hard, pressuring every angle of his situation. Labeling it a pursuit doesn't undo a judge's clear order for openness after weak claims. This story continues to develop. Stay tuned.